Great. Well, thank you so much for inviting me to speak here today. It's a great honour for me, and also, I should say, just a little bit nerve-wracking. I'm used to having a much more captive audience. I realise you could all get up at any moment and leave. So I'll try to entertain as well as be thought-provoking. What I want to talk about today is the impact of the rise of international terrorism and attempts to counter terrorism for all of us, for university students, researchers and professors. And I'm going to do that by reference to some developments, recent developments in the United Kingdom, but ones which I think also have resonance for everybody working in universities, certainly throughout Europe. So before I begin, let me just say a little bit about the background, and this probably will be well known to many of you. Since 9/11, obviously the whole security landscape has changed, but it's changed several times, and since 2014, and with the rise of the caliphate founded by the so-called Islamic State, ISIS, we've seen the new concern throughout many West European countries about the radicalization and recruitment of members of our own communities who have been radicalized and gone to fight in conflict zones in Syria and Iraq as so-called foreign terrorist fighters. And I'll be using that term throughout. You can see from the figures there, these are all estimates, but something like 42,000 people globally from 80 countries have gone to Syria and Iraq to fight. From Western Europe alone, we estimate around 6,000 people travelled to join terrorist organisations. And that mass movement, unprecedented mass movement of people to fight abroad, has prompted international reaction and concern. And in 2014, the United Nations Security Council passed a number of resolutions imposing upon all member states the obligation to take action against terrorist fighters, and in particular to act to prevent their recruitment. Now, during the life of the caliphate, the chief concern was about people going abroad, about stopping people from travelling to join conflict zones. As the caliphate has retrenched and finally in early 2019 has fallen, what we've seen actually is a new set of concerns about so-called returning foreign terrorist fighters. What will happen when those who have gone to fight in conflict zones, who have been radicalised, who may have been exposed to quite brutalising effects of war and conflict, come back to their home countries? And we know that by about 2018, well over 7,000 ISIS recruits had come back to their countries of origin. In Europe, the figure is thought to be somewhere over 1,700. Actually, the numbers have gone up a little bit even since then, have come back to West European countries. Alongside all of that, and perhaps less readily acknowledged, there's the rise of right-wing extremism and of neo-Nazi groups. Just to give you one set of figures there, whereas there was only a single terrorist incident caused by right-wing extremists in 2007, 10 years later there were 28 such incidents. And again, that changes the whole landscape of terror and the need to counter terrorism. Now, counter-terrorism is very often thought of as a balancing between the collective right which we all enjoy to security with the individual rights of those who are subject to a whole array of coercive counter-terrorism laws, criminal laws, security laws, coercive measures, surveillance, and so on. And that use of those measures and laws is necessarily, inevitably erosive of rights. So much so that in the wake of 9/11, the American political theorist Ronnie Dworkin said, the difficulty of balancing rights is that, I'd like to attempt his accent, but I think it probably would be unwise. Maybe I'll have a go. The only balance in question is the balance between the majority's security and other people's rights. Well, Ronnie might have been, I know it was bad, I'm sorry. Ronnie might have been right when he made that statement back in 2006. But what I want to suggest to you in the remainder of my lecture is that actually it's no longer a question of other people's rights. The laws and the measures that I'm about to talk about affect every single one of us, whether we're students or professors or simply interested members of the public. Before I drill down a little bit and to look at particularly how these counter-terrorism measures affect the university, it's perhaps just worth remembering that there is a whole array of laws that are directed against free speech. And I made it my mission to have a look at the criminal code here in the Netherlands. And many of the laws that I've put up on the screen there that apply in the UK also apply here. In fact, your laws aren't, perhaps as one might expect, aren't quite as extensive as UK laws. You don't, for example, have a crime, so far as I know as yet, of glorifying terrorism. In the UK, we have a whole set of laws you can see there. Most recently, and I think perhaps most worryingly, is the one under the 2019 Act, which makes it a criminal offence to view on a single occasion material online, material that is of a kind likely to be useful to a person committing or preparing an act of terrorism. Simply viewing such material on a single occasion carries a maximum sentence of 10 years imprisonment. So I just want to make clear to you the extent to which our ability to carry out research, to discuss ideas and to debate controversial opinions is now impinged on by laws such as this. I should say, as I am a lawyer, I should say there is a reasonable defence to that viewing terrorism material online, but the defence only kicks in once you find yourself in court, so it remains pretty problematic. And if you want to get some sense in the way in which the law is being overextended, just look at this provision, the encouragement of terrorism offence, and you have something quite similar here in the Netherlands. It's an offence to make a statement likely to be understood by some or all members of the public as a direct or indirect encouragement or other inducement to the commission of preparation or instigation of acts of terrorism, being reckless as to whether any such encouragement may take place. So that places me as somebody who's daily giving lectures on terrorism and counter-terrorism at risk of inadvertently, recklessly making a statement that might be deemed by one of my students to be an indirect encouragement to prepare or commit a terrorist act. Alongside all of those laws, those hard criminal laws and security laws, we have in many countries, including the Netherlands, including the United Kingdom, soft power measures which are designed to nurture toleration, to create greater community integration, and to try to prevent people being drawn into terrorism before they actually commit terrorist acts. We have a program known as the PREVENT program. Many countries, Canada, Australia, UK, have PREVENT programs, which are intended to encourage communities and civil society institutions to come together with public institutions to try to identify those who are at risk of being drawn into terrorism and to help them, to divert them, to de-radicalise them before they go any further. And as part of the UK government's PREVENT strategy, certain public institutions have been identified as having a particular responsibility, and there's a quote on the screen for you there by the UK government in respect of universities. Universities have a clear and unambiguous role to play in helping to safeguard vulnerable young people. Those of you who are in the audience who are young may also be vulnerable young people from radicalisation and recruitment by terrorist organisations. So why are universities under suspicion? It's not particularly obvious that we should be looking to universities to play a part in counter-terrorism or to think about young people as being particularly vulnerable. But there is some evidence to suggest that youngsters are more likely to be arrested for terrorist offences. I give the figures there from Europol, who report a third of those arrested for terrorist offences are under the age of 25 or younger. In 2016, the World Bank, why the World Bank, I've no idea, the World Bank got hold of a whole tranche of leaked ISIS records, and they found that recruits were likely to be well educated relative to levels of education in their own country, and relatively wealthier than most people. In the UK, that kind of evidence has accumulated to suggest to politicians that universities are breeding grounds of terror, host to extremist speakers, groups and event. And there's been a real ramping up of the sense that universities are not playing their part, and as they should be, in preventing the spread and communication of extremist views on campus. So what we've seen in recent years is a sort of hardening, if you like, of soft power. That is, instead of relying upon integration and tolerance and support, we're actually moving to thinking that we should be actively protecting people. And I quote from the leader of the UK House of Lords, our senior parliamentary chamber, from the poisonous and pernicious influence of extremist ideas, which are used to legitimate terrorism, to make sure that key bodies, and universities are one of them, play their part in that partnership against terrorism. What happened as a consequence of that shift is the legislative enactment of a single provision, and much of what I'm going to say from now on is going to relate to the words in gold on the screen in front of you. Section 26 of the 2015 Act said a specified authority, and there at the bottom of the screen you'll see just some of those specified authorities. Interestingly, they not only include universities and schools, but even kindergarten are specified authorities under the Act, must, in the exercise of their functions, have due regard to the need to prevent people from being drawn into terrorism. It's a very short provision. It's not a very clear provision, and yet it's attracted enormous consternation and outcry and protest on campuses all over the United Kingdom. And I'd suggest it's something you should be alert to, because what happens in one country has a curious way, by way of policy transfer, of appearing in other countries very rapidly. So far as I'm aware, universities here are not yet under such a duty, but I don't think you can assume that that will always be the case. So what does this duty to have due regard to the need to prevent people from being drawn into terrorism actually mean? And what does it mean for universities in particular? Does it turn professors like me into police and students into subjects or suspects? Or does it, counter view, does it actually just simply fulfill the university's obligation to safeguard younger people? And the language of safeguarding and safe spaces has become, I think, very prominent across all universities these days. Or is it, as I want to suggest to you, a much more complex story of competing interests, rights and duties, and the interplay between all of those? So let's drill down a little bit and think about this. One of the difficulties with the phrase, and I put it back at the top of the screen there, one of the difficulties with it is it's quite unclear what it actually means. And though there's very specific guidance on the meaning of the law, it doesn't help us very much. So we're told in the guidance that due regard will be satisfactorily demonstrated if universities or other institutions have appropriate policies and processes in place. Appropriate doesn't tell us any better what it is we need to do or how we need to do it if we're not to fall foul of the law. A key word is, words are terrorism-related offences. But again, in the guidance, they're defined as those judged to be committed in relation to terrorism. Well, that's really helpful, isn't it? And then this bit, actually, I almost feel embarrassed to tell you the definition of extremism. The little row of flags is there for a reason. Extremism is defined in the negative. Extremism is vocal or active opposition to fundamental British values, including democracy, the rule of law, individual liberty, mutual respect and tolerance of different faiths and beliefs. Of course, these are exclusively British values to which no other Western nation, or indeed any nation, can reasonably lay claim. I'm sorry, Netherlands, these are British values alone. But anybody in the audience who's who's a lawyer will notice that there's another word in this definition which is even more worrying. Anybody want to guess the really, really worrying word? No takers? It's the word including. Including. So this isn't a prescriptive or complete list. It's a list of exemplary British values. And there may be more. The failure to comply with or opposition to those values might themselves constitute extremism. Failing to queue at every opportunity is a central British value. Valuing dogs more than children, also very, very important British value. Apologising at every opportunity. Any kind of extreme opposition to such values could be added, I think, to the list. So really we're none the wiser about what we need to do or what it means when we describe somebody as an extremist. And there's a further concern, a perhaps more serious concern, about whether or not such a duty is compatible with the role of the university. It's accepted, I think, not only in Britain but everywhere, that universities are places which should encourage inquiry, should encourage controversial debate and contestation, that they're places where rights to free speech and academic freedom are really important. And the problem is that there's a real risk that what we do when we impose such duties upon universities is we criminalise curiosity and we make illegitimate, legitimate kinds of inquiry. It's also the case that because this duty is so vaguely worded on the face of the legislation, all the discretion in terms of its definition is delegated to executive power, and that curbs rights of parliamentary scrutiny, public debate, democratic deliberation, accountability. We're reliant on the executive or other bodies to tell us what the law really means and how it should be complied with. And there is no shortage of such guidance. In addition to the 6 official documents that tell us what, from the government itself, that tell us what that duty entails, there are documents put out by universities, by schools, by prisons, by hospitals, and by every single individual institution. So at my own university, there are 36 separate colleges. The prevent duty falls on the university as a whole, and it also falls on the face of the law on each college in turn. So if you're just working in Oxford, quite aside from the government instructions, the university sector-wide guidance, there are 37 further documents that you probably need to have reference to in your course of university life. What do we have to do in order to comply with all of this? Well, the very short answer is a lot. We have to assess risks, we have to institute action plans, we have to set up mechanisms for so-called information sharing about vulnerable individuals. It turns out that those people we identify as vulnerable are referred or made known not only to the university security services, but in the case of my own university at least, the security services are in direct communication with the head of counter-terrorism in the police for the whole of England, so that this vulnerable person becomes, if you like, a suspect very rapidly the moment they're identified. We also have to enforce restrictions on external speakers and events, and I'll say a little bit more about that in a moment. And we have to monitor online computer activity such that if I ask a student to undertake research on terrorism-related activities or employ a research assistant, as I did last week to do some research on right-wing extremism, I have to give the name of that student to the university authorities. Otherwise, that student is liable to find themselves being contacted by those authorities as somebody who is vulnerable to being drawn into extremism, for which read criminal suspect. Certainly there's been a lot of concern in the UK that the terms of the duty are so vaguely worded that it's just not possible for people like you or me to know whether we're in breach or not. And we can't actually conduct our usual university research or even indeed our teaching without taking risks that we are falling outside the duty. But where universities don't comply, where they don't actually fulfill the terms of the duty, they can be expected to be told very firmly by the government that they have failed to comply with the order. So as you might expect, there's been huge pushback from students who have, across campuses in the UK, have opposed this duty and said, we're students, not suspects. That Prevent is racist, that it's Islamophobic, that it targets particular communities more than others. It's also the case that many of us have protested on the grounds that there are certain assumptions underlying the duty which are really questionable. Are universities in fact sites of radicalisation? Does exposure to extremist ideas actually necessarily lead to radicalisation? And even if it does lead to radicalisation, does it lead to action? And anybody who's studied radicalisation will know that the experts tell us that there's a very big gap between so-called cognitive radicalisation, that is, absorbing radical ideas, and behavioural or conduct radicalisation, that is, actually acting on it. Many young people spend their time in their rooms with, if you like, bad internet habits of finding things which are shocking or provocative or just interesting, but are no way actually on the path to radicalisation. There is also an assumption that risks can be fully mitigated, and I'll have a word more to say about that in 1 second. But universities are obliged to fully mitigate the risks that they identify. And then finally, there's this idea that you, all of you, are vulnerable young people who are susceptible to extremism and in need of support. And we've got these nice posters here with lots of hand-holding going on. Extremism, it's a team effort. It all sounds rather supportive and kindly, until you think about the government's latest initiative, which is to set up a new commission for countering extremism, which has somebody with an automatic weapon looking down the sightlines of that weapon straight pointing at you. Notice that we're not talking here at any point about violent extremism. In the UK, we long since abandoned the word violence. We have no requirement that extremism be violent. It's enough simply that you express views which are hostile to or in opposition to those exclusively British values. Notice also that in the Queen's speech 2017 announcing this new commission, the language of supporting vulnerable people is replaced by the Commission working to stamp out extremist ideology in all its forms. Though I have to say, I do think it's quite cool that our Queen, aged 93, tweets, which is more than I do, but there you go. And then, of course, there's a concern about the relationship between this duty and fundamental freedoms to expression and academic freedom. You'll be well aware that under Article 10 of the Convention there is a protection of the right to free speech. But as Banksy shows in this rather wonderful little bit of graffiti, conditions apply, and at the bottom you can see there are a whole host of restrictions on free speech which appear even on the face of the Convention. So there's a bit of a question about just how free speech really is. In the UK, universities actually have further protections and indeed obligations. So it's not enough merely that we allow free speech in UK universities. We actually have a legal obligation to uphold free speech, to make sure that it's secured for all members of the university. And in addition, academics actually enjoy something quite interesting called academic freedom, the freedom to question and test received wisdom, to put forward new ideas and controversial or unpopular opinions. That's a legal protection of academic freedom. And even on the face of the 2015 Act, although universities are required to have due regard to prevent people from being brought into terrorism, drawn into terrorism, we have a duty to have a particular regard to the need to uphold freedom of speech and academic freedom. So we've got a stronger duty to free speech than we do to academic freedom. And then, even outside of the law, just remember that free speech is something fundamental to university life, and it goes way beyond just those kind of legal requirements. That for universities to be in any sense recognisable as it says here, important pillars of civil society, they must be places where differing and difficult views can be brought forward, listened to, and challenged. The difficulty of maintaining that is, I think, exemplified by one last example, which are the implications for universities of their duty in respect of outside speakers. And I talked earlier about full mitigation of risks. So here's one thing that we're supposed to do when we invite an outside speaker, such as myself. When we decide whether or not to host that speaker, we can only go forward if we think there's a risk of extremism where we're convinced that the risk can be fully mitigated. If we can't fully mitigate that risk, for example, by ensuring that their views are opposed and refuted on the same platform in which they speak, then we have to cancel that event. And I think that that's really been very problematic, so problematic that just a few weeks ago, in fact, the Court of Appeal in the UK found that this guidance is unlawful. It's been found to be unlawful, but as yet the UK government, which is busy with some other matters, I have to say, which are diverting it, the UK government has done nothing about that ruling. It still stands. So, just in the interests of balance, I can't fully mitigate the risk that I will be seen as an extremist, but I can try and offer a little balance. The counter view might be that universities are democratic institutions. They have a democratic responsibility to join in the larger role of safeguarding students, of countering terrorism. That freedom of speech is not an absolute right, that it's subject to restrictions, as I've already said, and that we can actually just about bring ourselves inside of the duty by exercising what one might call a light touch. All of that is all well and good. The question is whether the duty should be there in the first place. And what I want to do, just by way of conclusion, is go back to those fundamental British values which I referred to earlier. Democracy, rule of law, liberty, respect and tolerance. Democracy, and yet the very legislation by which this duty was brought in was fast-tracked. There was very limited scrutiny, almost no debate, and all the detail is delegated down to the executive. The rule of law is not really satisfied by this duty. It's incredibly unclear what it means. It doesn't provide fair warning. There's no due process. We don't have a right to challenge the application of the duty against us. Individual liberty. It's clear, I hope it's been clear from my lecture, that the duty to counter terrorism on campus impacts very profoundly on individual rights. And then as for mutual respect and tolerance of different faiths and different beliefs, well, I think I'll rest my case there. I'm rather hoping that Tahir might have more to say on precisely that issue. So I thank you for your attention, and I also want to end just with a word from our former Prime Minister, which will give you a sense of where the debate has gone and how we've got to this place. For too long, he said, we've been a passively tolerant society, saying to our citizens, as long as you obey the law, we will leave you alone. But this government will conclusively turn the page on this failed approach. Thank you.